Hello, everybody. My name is TJ Scott, or Timothy Scott. I'm the owner of the law office of Timothy J. Scott, and I am an estate planning attorney. And what that means is I help people get their affairs in order so that their families are protected when something happens to them, meaning incapacity or death. And I'm so happy to have you here with me today. I know that we're going to be talking about a really difficult topic today. Um, but I also believe that knowledge is power. And today, that's really what I want to do. I want to empower you. I want to educate you, and I want to give you some peace of mind around the topic of estate planning, and in particular around the ideas of guardianship, wills, and trusts. Just knowing what's going on in this realm can bring a lot of peace to you and to bring a lot of peace to your family. So today I have a lot of valuable information that I want to share, including some valuable offers that I'm going to be sharing at the end of the presentation. So I hope that you'll stick around and hear those. But the best way to learn, the best way to be here with me tonight is to really be present with me. Now, you've given yourself this time, you've set it aside so that you can really be here with me and join me. And I encourage you right now to turn off the distractions. If you have something like another window open or something like that, and I'm checking a friend somebody who tried to join these one time, really struggled to join last time. So I'm trying to see if I have any emails from him. I'm doing a bad job of demonstrating the turn off the distractions. If you have another window open, I really encourage you to shut it down and just give yourself this time that you've already set aside to be with me. And I always say your future self will be glad that you took the time to devote to learning this topic tonight. And if you stick around until the end tonight, I do have a couple of valuable offers that I want to give you. The first is how you can get a free virtual one-on-one meeting with me, where we're going to talk about the people that you love and the things that you have. And we'll talk about exactly what's going to happen in your specific case, and what it means for your family and your specific case study. All these things about estate planning. You can learn. You can talk to me, and I'll share that information with you from the information that you're sharing with me. Plus, I also have a bonus gift that's going to make it even easier to get a personalized and tailored estate plan in place. And again, I hope that you'll stick around and learn about that. But the first thing that I want to do here is kind of get a feel for the audience. I want to find out, do you have an estate plan already? And you should see a poll pop up. You can select yes or no. Do you have an estate plan in place right now? And I have some things listed here on the screen. A trust, a will, guardianship nominations, if you have minor kids, healthcare directive, power of attorney, beneficiary designations. These things are all part of an estate plan. A good estate plan should really involve all of these things. Sometimes it doesn't involve a trust. Sometimes it doesn't involve guardianship nominations. It really depends on the people who are doing the estate plan and their particular case. But most often, a real estate plan, an estate plan that's going to take care of the people that you love after you're gone, is going to include all of these items. And right now, it looks like most people are saying no, but I do have some yeses as well. But generally, it looks like we have an audience that hasn't done estate planning yet. And I can tell you, if you haven't done an estate plan yet, you're not alone. About 69% of people in the United States don't have an estate plan. It's always hard to estimate, but those are the most recent estimates that I've seen. And so my question for you is, if you haven't done an estate plan, why not? And you might have one of these. One of these might look familiar to you. Maybe you've been too busy, and trust me, I get it. Life today is really busy. You know, I have three little kids. Our oldest is 9 years old, and so I know exactly what it's like to be running around and chasing kids and busy. Um, but if that's the case, I really, again, want to commend you for being here tonight and starting the process, getting the ball rolling. And I hope that you'll continue along and get a full estate plan completed. Maybe you feel like you're too young. And honestly, anyone over the age of 18 really should have an estate plan. I recently helped a young family where a father had passed away at a really young age. And Unfortunately, he had left kind of a mess for his wife and minor daughters. But it didn't have to be the case. It didn't have to be that way. He could have gotten an estate plan in place that really would have protected them, really taken care of them, and handed off the finances, handed off the assets, and handed off the care for that family to somebody who could have handled it. Maybe you feel like estate planning is too expensive, and I will say, before word processing was in place, estate planning was very expensive, and it really was just for the wealthy. And it still has a bit of that tinge to it that a lot of people think estate planning is just for the ultra wealthy, the Uncle Scrooge McDuck or something like that. But that's not true. Today, estate planning is for everybody. And again, we have word processors. It has become more and more affordable for everybody. And again, I'm going to have some bonuses at the end that you'll see will make it even more affordable to get a great estate plan in place for the people that you love. And maybe you're worried about jinxing yourself. And I see some people saying that, yes, they're worried about jinxing themselves. And I'm glad that you fessed up about that. I can tell you, I have done dozens of estate plans, and luckily, I have never seen a correlation between doing an estate plan and having something happen to a client. In fact, my clients, I believe, live more intentionally and get more out of their life after they've done their estate plan because it's a weight off of their shoulders. It's something that they know that they don't have to worry about anymore. So thank you for sharing those responses with me. I know that some people did have estate plans in place, and whether you have an estate plan in place or not, I'm curious, what do you want to learn here tonight? And maybe you want to know if an online will is going to be enough to protect you. And I've got that question a lot. I've got the question of, I want to do it myself. I want to legal zoom it, or wills. I don't know, is wills.com a thing? Probably. I don't know. I hope that I didn't send anybody down a weird rabbit hole with that suggestion. But yeah, I know that that's a question that a lot of people have right now is this something that I can do myself? Is it something that I can handle on my own? And I'll talk about that tonight. And I'll talk about what kinds of things you can do yourself and what kinds of things you shouldn't do yourself. Maybe you've done a plan in the past and you're wondering, is my plan outdated? Sure, my plan names minor kids and all of my kids are above the age of 30 now, but do I really need to redo my plan? And I'll talk about the things that you should look for, things like changes in the law, changes in your family, changes in your assets that mean that it might be time to at least have that plan looked at by somebody like myself, somebody who's working an estate planning attorney. Maybe you just want to get a better understanding of your plan. And I know I hear this from a lot of clients who've done a plan before, that their previous attorney didn't do a good job of describing or explaining exactly what their plan was and what it did. And so they're confused about what it means and what all the different pieces are. And there are often a lot of different pieces to an estate plan. And that's something that I'll talk about tonight too. In fact, you're going to get, through this webinar, you're going to get a really good picture of all of the different pieces of an estate plan. And if you still have questions at the end, I really hope that you'll reach out to me and schedule a meeting with me so that we can talk about it. If you have a specific question that you want me to answer today, I said this before, but we've had quite a few people jump in now. You can either put that question in the chat or you can put it in the Q&A portion and I will see it. If you're feeling especially brave, you can raise your hand, in Zoom parlance, and I can actually unmute you and you can ask your question out loud. But I know that that's a lot to ask, so I'm not going to be doing that to surprise anybody. No, but feel free to ask your questions in chat or with the Q&A portion. And I'm seeing one thing that's really sticking out that a lot of people are curious about is an online will okay? So I'll make sure to devote special time to that in the presentation here today. Whatever the case, whatever it is that you want to learn and wherever you're coming from, you're in the right place here tonight. You're in the right place if you have someone or something that you care about and that you want to protect, and you know that you're not going to live forever. None of us in this room or none of us in this Zoom are going to live forever. You're also in the right place if you did an online or fill in the blank will, and you're not sure if it's going to work, but you're kind of hoping that it is because it was cheap to do, and you feel kind of accomplished by doing that do-it-yourself will. And you're also in the right place if you're nervous about how much this is going to cost. And I completely understand that. And I've heard that concern from a lot of people before. And I want you to know that it's something I'm going to speak to very explicitly towards the end of this presentation, to let you know exactly what you should look to spend on getting a great custom estate plan in place. But the reality is, estate planning isn't about you. It's really about the people that you love. And it's really a gift to the people that you love, because you're able to secure them and give them security in a way that they really need it at the moment that they really need it, when they can't turn to you, when they can't ask you to take care of them anymore. And your loved ones are going to know whether you lived up to your promise to take care of it at the end of your life. And those three kids on the screen, those are my three kids. From the left to right, it's Margaret, who is 4 now, Ben, who is 9, and Elizabeth, who is 6. And I'll show you another picture of them in just a minute. Don't worry, lots of pictures of the kids tonight. I see somebody saying, how does a trust impact taxes for your heirs? And that's a really fantastic question. A revocable trust can provide some tax planning that can be beneficial for your heirs, but it has to be written the right way in order to do that. So if you're married, there are things like a disclaimer trust or a Clayton election trust, AB trust. There are different trust options that can make sure to take advantage of the estate tax. The estate tax exemption here in Minnesota is lower than on the federal level. In Minnesota, we have an estate tax exemption of $3 million. Anyway, suffice it to say, there can be tax impacts of having a trust. Generally, if they're written the right way, those tax impacts are only good. And we will talk about that a little bit more here tonight for sure. So here's what we're going to cover today. We're going to talk about planning for incapacity, and we're going to talk about planning for things like who would make healthcare decisions for me if something happened and I wasn't able to make those healthcare decisions myself. And the same thing for financial decisions. Who could help take care of my finances for me if something happened and I wasn't able to take care of my finances? We're also going to talk about what is going to happen when you pass away. And it's a sad fact, but we're all going to pass away someday. So it's something that we really need to plan for. And we're going to talk about guardianship. If you have minor children, who has a legal right to take those children and raise them until they're 18? And do you want a judge making that decision, or do you want to make that decision during your life? We'll also talk about probate, and we'll talk about why most people want to avoid it. The fact that it takes a long time, that it costs a lot of money, and the fact that it's public mean that a lot of people want to avoid it. We'll talk about estate taxes. I know, again, that I had a question about that, and we will talk about that here tonight as well. We'll talk about unclaimed property, which is something that you often won't hear an estate planning attorney talk about, but it's something that I think is really crucial. Really stewarding all of your assets, or shepherding all of your assets, so that they get to the people that you love and nothing is lost to unclaimed property. And we'll also talk about your intangible assets and how you can capture things like your values and your stories for after you're gone and for the people that you love. But before we get into that, I would just like to tell you a little bit about myself, since we're going to be spending some time together tonight. So this is my family, and we live in Bloomington, Minnesota. My wife's name is Tobin, and my kids are Ben, Elizabeth, and Margaret. That time I did it in kind of a random order. So Ben is on the right, Margaret is in the middle, and Elizabeth is on the left. And my family is really my whole world. I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the very next day, my first child, Ben, was born. After graduation, I found a job with a small estate planning and tax preparation law firm in Minneapolis. And I loved the clients that I was able to work with. But at the same time, I didn't always feel like I was providing the amount of value that my clients really deserved. And so a little after 3 years after joining the firm, I actually left. And this is a picture from my last day there. Someone has to graduate at the bottom of the class. Now, this was not said about me. This was something that my parents said about an attorney who had helped to plan my grandmother's estate. And it's something that has really stuck with me throughout my entire life. Someone has to graduate at the bottom of the class. Uh, and there was a big reason that my parents felt let down by the estate plan that this attorney had written for my grandmother. But the fact of the matter was, I don't really think that he was a bad student in law school. I don't actually think that he got bad grades or anything like that. Um, I think that it was the model that he was practicing under, the type of estate planning that he was doing, which is a very traditional, faulty model. And I'll talk about that a little bit later. But first, let's talk about some of the aspects of estate planning. And so here, I wanted to ask everybody's question, or I wanted to ask everybody this question, kind of a demographics question, and find out where people are coming from today. Because I'm going to talk about short-term guardianship, I'm going to talk about long-term guardianship, and those really apply mostly to people, those really apply to people with young kids. And so I'm seeing some people who are married with young kids. I'm seeing some people who are single with grown kids. I'm seeing some people kind of across the board here. And so I will speak to everybody. I'll speak to the concerns that everybody has. But I would like to spend a little bit of time on this short-term guardianship and long-term guardianship because it seems like it's going to be really relevant to a lot of people who are joining us here tonight. So short-term guardianship, if you do kind of a thought experiment, if you have minor kids and you and your spouse went out on a beautiful date night, but for whatever reason, you didn't come home and the babysitter was sitting there with the kids and didn't know why you weren't showing up, but just knew that you weren't making it home that night. And there was no plan in place telling that babysitter what to do. Eventually, that babysitter is going to call the police. They're going to get the police involved, and likely your kids are going to need to spend some time with Child Protective Services. If there isn't some sort of document in place, if there isn't some sort of plan in place that says who legally can have access to those kids for a short-term period of time. And I think Child Protective Services does the best job that they can. And I'm not here to say anything really negative about them other than I know that I don't want my kids going into a foster system or going into a Child Protective Services system, even for a minute. I have people in my family that I would want to be able to take care of my kids. I have people in my family that are very close to us who, proximity in local to us that I know would come over and would take care of the kids and would make sure that they were well taken care of until our long-term guardians were in place. And so this is something that I think is really important to plan for. It's something that not every estate planning attorney plans for. But if you don't have guardianship in place for your kids right now, this is something to think about. Is you want to plan not just for long-term guardianship, which is often named in something like a will, but you want to plan for short-term guardianship as well. Who can have those kids for the first hour, the first day, the first week, until your long-term guardians can be contacted. So long-term guardianship is really the flip side of that coin. Who has the right to raise your kids until they're 18? And who are they going to thrive with? Whose direction are they going to thrive under? Thanks again, everybody, for sharing with me in that poll. And so if you don't have a plan in place, if you haven't named guardians in a will, or if you haven't named guardians in a standalone document, there is a plan for you. And the plan is that a judge is going to decide. And if a judge decides that Uncle Larry is the very best person to raise your kids, even though you know that Uncle Larry is not going to do the best job, that your kids are not going to thrive with Uncle Larry, then a judge may decide that Uncle Larry is the person who gets guardianship. But you can put nominations in place. You can get this decided, and you can decide it. You can control it during your lifetime. And so that's so important if you have minor kids to make sure that you get guardianship nominations in place. And I know that there are some people with grown kids tonight. I believe that there are some people without kids, but we all know people with minor kids, and we all know how important those kids are to our friends and to our family, and how important it is that they have the right person to raise them. So, how are people going to receive the assets that you want them to receive? And if you don't have an estate plan in place, or if you have done an estate plan, but that estate plan is based on a will determining how your assets go to the people that you want them to go to, there is a process for you. It's a court process called probate. And what probate is it's a lawsuit that you file against yourself with your own money for the benefit of your creditors. And you can see that down in the lower left-hand corner, a lawsuit that you file against yourself with your own money for the benefit of your creditors, for the benefit of the people that you owe money to. And when you pass away, the people that you owe money to want to make sure that they get paid. And so the state has put in place this process that is one size fits all. Whether you have an estate that's worth $10,000, well, not 10,000, but if you have an estate that's worth $75,000, or you have an estate that's worth $100 million, if you're Prince, probate is the one size fits all solution that is going to take care of deciding who gets what. And probate is slow. That's one of the first things that you should know about probate. In Minnesota, probate takes a minimum of 6 to 12 months. And more often, it takes something like 12 to 18 months to get through. And the fact is that we'd like it to go faster, but it's not designed to be a fast system. It's a court process, and it's a court process that requires certain notices to be given and certain waiting periods to be waited through in order to make sure that your creditors are able to get to the court and get paid if they want to. Probate is also very costly. There are attorney's fees, executors' fees, appraisers' fees. I don't have to read them all off to you. You can see them there. But there are all these fees that go into probate and that you have to pay through probate. Attorney's fees are a big chunk of those. But again, there are other fees. And probate in Minnesota costs an average of 3 to 6% of the gross value of your estate. And so you can imagine if all that you have is a house that's worth $400,000, a reality that's truer and truer with the prices of real estate going up and up, probate already would cost somewhere between $12,000. It's 3% of a $400,000 house, and $24,000, which is 6% of a $400,000 house. Probate is very expensive, and it just dilutes the amount, or it just takes away from what your heirs are able to receive. And we'll actually have a chance here in just a minute to do some back of the envelope math, and you'll be able to kind of get an estimate for what probate might cost for you, again, in just a minute. Probate's also public. So I'm showing you here Anna Nicole Smith's will. And some of us might remember her. Wills are totally public, and having a will doesn't avoid probate. I know I said that just a minute ago, but if your estate plan is centered on a will, that doesn't mean that you're going to avoid probate. That's a huge misconception that a lot of people have, that I can just go on LegalZoom and do an online will myself and avoid probate. But in fact, having a will ensures that there will be a probate, because there's this funny saying that we have in the estate planning world: where there's a will, there's a probate. And when you're basing your estate plan on a will, the court needs to read that will and interpret it. And the process where they're going to read that will and interpret it and decide what your heirs get is called probate. And so when a will enters probate, it puts all of the creditors out there on notice that your loved ones are going to be receiving money. In fact, in probate, oftentimes you have to complete an inventory and a final accounting, which says exactly where those assets are being distributed to, the names of the people that the assets are being distributed to. So you can imagine, if you have somebody who's kind of vulnerable, somebody who's a little bit naive, having a creditor on notice that they're receiving a bunch of money is the opposite of what we should want for that person. Finally, kids are entitled to receive the assets at 18 and unprotected. And I like to think that I was a pretty mature 18-year-old. I just said this to my mother the other day and she shook her head. But I like to think that I was a pretty mature 18-year-old. But I can tell you, when I was 18, if I had inherited a bunch of money, I don't know if I would have gone to college. I might have, I might not have. But I definitely would have bought a Corvette and I would have driven around really fast. Because that's what I was thinking about when I was 18. I was thinking about things that were short-sighted and weren't really going to bring me fulfillment over my lifetime, but just some short-term fulfillment. And so, as a relatively mature 18-year-old, if that's the kind of decision that I'm making, I think we can all imagine that we don't want our kids or we don't want whoever it is receiving assets at 18 and unprotected. Um, Something to think about. So here's your opportunity to calculate your own probate estate. And so you can see here that I've included things like the family home, maybe a rental property or a cabin. I've included furniture and household goods. $20,000 to $30,000 is generally pretty reasonable for that. If you have a lot of jewelry, a lot of very fancy jewelry or watches, that number could be higher than $20,000 or $30,000. Automobiles, I've included stocks and bonds and bank accounts, and also a business interest of $100,000. You can see that that all totals 850,000. Excuse me, $850,000. And you can get 5% of that number really quickly by just moving the comma over one place. So instead of 850,000, you have 85,000, and then dividing that number in half. And so you can see that's how I got $42,500, which is an estimate of what this kind of probate might cost. Just to add a little wrinkle, add a little complication, if you have life insurance or retirement accounts that are payable to minors, then those assets are also going to need to go through probate. And oftentimes, if they're payable to a beneficiary, they can go directly to that beneficiary. But if they're payable directly to a minor without something like UTMA provisions in that policy or in that contract, unfortunately, they're going to need to go through your estate. They're going to need to go through probate so that somebody can hold on to that money until that minor is 18. And so if you add in some life insurance, you add in some retirement accounts, a total 1.5 million, all of a sudden you can see how the cost of probate really explodes. Not that 42,500 wasn't already expensive, but it can get very expensive. But there is a foolproof way to avoid probate, and that's by fully funding something called a living trust, or sometimes it's called a revocable trust. And so a living trust or a revocable trust isn't a specific bank account that you have somewhere. It is actually an agreement that you write. And it's an agreement between three parties, between the person who's creating it, which would be you, the person who has the control over the trust, which again would be you, and also the person who can benefit from the trust, the beneficiary. And that again would be you during your lifetime. So it's the person who creates it, the person who controls it, and the person who benefits from it. And when you serve in all three of those roles, that's called a revocable trust or a living trust. And so you write out this agreement, an attorney writes out this agreement, and that's one very good step. But it's not just that document. It's not just that agreement that is the end all be all. You also have to make sure that you fully fund that trust. And that means putting all of your assets into the name of the trust. So if you have an investment account, it means going to that brokerage or going to that, Edward James or whoever it is, Raymond James, Edward Jones, whatever it is, and actually retitling that investment account so that it's held in the name of your trust. It means going down to the bank and putting those bank accounts in the name of your trust by signing new signature cards so that you are able to access them as trustee, but really they're titled in the name of your trust. It means executing deeds to real property in order to transfer those parcels of real property into the name of the trust. Transferring stock and bond certificates assigning personal property, which is one of the easiest things that you can do because it's just a single document called either a bill of sale or an assignment of personal property that puts those assets into the living trust, or changing life insurance and retirement account beneficiary designations. And there are some pretty specific ways that you want to make sure that you do that, especially around retirement account beneficiary designations, to make sure that you get the absolute best tax treatment for those assets. But this is something that is really important, and it's something that when I told you that at the small law firm that I was working at, that we didn't always serve our clients with the most value that I thought that we could. Funding the trust was one of the areas that we weren't fully serving our clients. And in fact, my managing attorney came to me one day and she said, great news, TJ, we have a trust that we wrote that is going to avoid probate. And I said, well, that's why we write living trust. That's why we write revocable trust, isn't it? So that they avoid probate. And she actually told me that about 9 out of 10 of the trusts that we were writing were ending up in probate, oftentimes because something was left out. They moved homes. Our clients would move homes and they would forget to put the new home in the name of the trust. Or something would change in the law, something would change in their assets, and there would be a gap. And for whatever reason, we would need to go through probate with that client. And that's not a good consequence. It's not something that you want to see. And so I'll talk about how I'm able to avoid that as an estate planning attorney, and why planning with me is really different than a traditional estate planning experience. So here's an opportunity to calculate your estate tax. And really with estate taxes, I get to give some good news. In Minnesota, we have a $3 million exemption. And so that means for your first $3 million, you pay nothing in estate tax. For your $3 million in first dollar, you start paying at 13%, and that number goes all the way up to 16%. And so if you have more than $3 million, it is very advisable to talk to an estate planning attorney and make sure that you have an estate plan that's written so that you can avoid those kinds of estate taxes. I know that doesn't apply to a lot of people. It doesn't apply to at least the majority of people, but it is something to think about. And if you are in that area where you're above $3 million, there's some great estate planning that we can do very quickly, especially if you're married, where we can actually double that exemption amount. But even if you're not married, there's some great estate planning that we can do to make sure that the estate tax, or the taxable estate that you would have at your death, is either below $3 million, or that you have assets that can pay for the estate tax that you would normally be paying on your estate at your death. On the federal level, the news is even better. There is an estate tax exemption of $11.7 million. And again, for your first $11,700,000, you pay nothing in estate tax. And so that's really good news. The estate tax rate at the federal level is extremely high. And so again, if you're above $11.7 million, you really need to talk to an estate planning attorney to figure out what kind of strategies you can employ to either bring your taxable estate down, or ensure that you have some money to pay for the estate tax, and that your estate isn't being wiped out before it gets to your heirs where you really want it to go. This is not the primary reason that most people do estate planning right now. And that's just because the exemptions are very high. They're historically high estate tax exemptions. But this is something that's very real, I know, to a lot of people. And so if it is an issue that you face, I encourage you to reach out. Will your assets be lost to the state? And so does anyone have any idea how much money is in our state Department of Unclaimed Property? I can tell you across the United States right now, that number is $58 billion. That's across the United States. And in the different state departments of unclaimed property, there's $58 billion that is currently in state departments of unclaimed property. And in Minnesota, it's $700 million. And a big part of the way that money gets there is somebody passes away, and their heirs, or their children, or their heirs, whoever is going to probate their estate or is going to clean up their estate, isn't aware of all of the assets that that person had during their lifetime. And so a bank account gets missed, or some stock gets missed, something gets missed, and ends up with the Department of Unclaimed Property years later, years down the road, when there's been no action on that item for a while. And it's really a shame. It's really something that doesn't need to happen, but oftentimes the work isn't being done ahead of time to make sure that we know where all of the assets are. Uh, I have done probate before. I've done probate, way back in the day. And part of what we used to do is collect the paper statements that people were receiving in the mail. And, and that was a lot easier to do when I first started doing probate, because people actually were receiving paper statements in the mail. But it's not so easy to do anymore, right? Because a lot of us have electronic statements turned on. And it can be very easy to lose assets, or to lose track of assets, and have it be very difficult for the people that we love after we're gone to make sure and collect everything that we had, to make sure that it gets to the right people. But again, this is something that you can do some work ahead of time and really get in front of, and make sure that you have your assets inventoried, and make sure that your assets are getting to the people that you want them to get to. This is really cool. You can make your living trust a real treasure chest. And you can really give your kids a real true gift with something called asset protection. And so asset protection means protecting their inheritance from things like a spouse in a divorce, or even from things like a creditor in a car accident, or a creditor from a lawsuit at some point in the future. And this is something that I am able to build into the trusts that I write. Airtight asset protection on that inheritance money. It's something that is really neat, and it's something that is very difficult for somebody to actually give to themselves. There are some attorneys who try and write asset protection trusts for first party people, or for first party individuals, but those asset protection methods often cost tens of thousands of dollars in order to employ. But it is very simple to do on an inheritance, for an attorney, for somebody who is practicing in this area. And it's something that I love to be able to include in my clients' estate plans. So planning for incapacity. I know that this is something that is very real right now for a lot of us. And some of us probably remember this person who is pictured on the screen. This is Terry Schiavo. And in the mid 2000s, Terry Schiavo was a name that we were all talking about, because Terry was in a vegetative state, and her family wanted two different things for her. Her mom and her dad wanted Terry to be kept alive at all costs, at whatever expense, whatever it cost. They wanted Terry to be sustained, and for her to be kept alive on a feeding tube, and with that kind of nutrition. Her husband did not think that that's what Terry would want. Her husband thought that Terry would rather not be kept in that vegetative state, that she would rather not be sustained on those kinds of methods, things like feeding tubes. And so her husband wanted the cord pulled, proverbial cord pulled, right? And because Terry hadn't detailed exactly what she wanted for her healthcare, there was a huge fight between her husband and between her parents. And this erupted into a series of court cases, and it erupted into into newsrooms and everywhere, to the point where everybody was talking about Terry, and everybody was talking about what should happen to Terry. And all this conflict and all this hurt and all these court battles were unnecessary, because you can decide, you can dictate exactly what you would want to have happen for your healthcare in something called a healthcare directive. And it's not difficult to write. It is, again, best done by an attorney, but it is something that you need to be proactive. You need to take control and do it during your lifetime, in order to make sure that you don't kind of become a cautionary tale like Terry was. And so that leads us here. What can you do today to do the right thing for your family? And what should it cost? And really, if something that I've talked about today has resonated with you, if the time, cost, and public nature of probate is something that you want to avoid, or if you fear being incapacitated and not having your wishes honored, if you're worried about losing assets to the Department of Unclaimed Property, if something here today has resonated with you, then you really have a couple of choices. You can either try and do it yourself and create a plan that is going to take care of the people that you love when you can't be there to take care of them, or you can work with a lawyer. And I will say, not all lawyers are the same. And so let's take those one at a time. Let's talk about, should you work with an attorney? Would you benefit from working with an attorney? And I have heard writing your own estate plan described as putting IKEA furniture together without the instruction manual. And it really is that difficult. There are that many moving parts and that many moving pieces that is really difficult to put an estate plan together that is going to work when you ultimately need it to work. And there's this story that I like to tell, because I personally am a big believer in do it yourself, and I like to do things myself. One thing that I was trying to do myself was, it was a little over a year ago, and I was going to take my son fishing for the first time that summer. And so we had gotten some new rods and reels, and I was attempting to put fishing line on one of the reels. And I don't know what I did, but I think that I wound it the wrong way, or I maybe put too much fishing line on the reel. Whatever the case was, as soon as I thought that I was done, all of a sudden, all of that line started jumping off of the reel. And I had fishing line everywhere, all over the basement. And I had to do a lot of cleanup. I had to waste a lot of fishing line, but it ended up okay, because I was able to figure it out. I was able to fix the problem and get the reel in a working condition where I was able to take my son fishing. So I had immediate feedback that my do-it-yourself project hadn't worked. I had immediate feedback that whatever I had done with that fishing line was not the right thing to do, and that I needed to go back to the drawing board and try it again. And I was able to do that, no problem. The problem with a do-it-yourself estate plan is you don't have any immediate feedback. The only feedback that you're going to have is after you're gone. It's the feedback that your family is going to receive when they realize that they're going to have to go through probate, even though you tried to write a trust that was going to avoid probate, or plan with beneficiary designations that you thought would avoid probate, or whatever the case is. Your family is going to have to deal with it when things like short-term guardianship weren't considered when you wrote your do-it-yourself plan. Or your family's going to have to deal with it when they can't find the main bank account that you had, and you haven't got paper statements coming to the house anymore, and it's looking like that money is just going to be lost, and it's not going to get to the people that you want it to get to. There is no immediate feedback in that do-it-yourself project, and that's really the biggest scary thing, and that's the biggest fear that I have when people tell me, I'm just going to do it myself. I'm just going to do LegalZoom. I fear that they don't have that immediate feedback, and it might not work the way that they really want it to work for their family when they can't be there. And so, again, let's talk about, would you benefit from working with a lawyer? And if you own more than just your personal belongings, the clothes on your back, things like your cars and clothing and jewelry, furnishings, if you own more than that, if you own your home, if you have a substantial bank account or brokerage account, if you have significant retirement savings or a life insurance policy, something like that, then you would benefit from working with an attorney. And if you want to ensure that the people that you love stay out of court and conflict and have someone to turn to when something happens to you, if you want them to have someone to turn to, you really need to have a relationship with an attorney that they can talk to after you're gone. If you want a kids protection plan, which includes short-term guardianship, long-term guardianship, and a bunch of other documents and different plan materials that really ensure that what you want for your children is what's done for your children, even after you're gone. Then you need to work with an attorney. And it's the same with if you want to avoid probate or estate taxes, or you want to protect your children's inheritance, then you really have to work with a lawyer in order to ensure and do that. And if you want to guarantee that your plan is going to work, that it's not a do-it-yourself project that's going to fail when your family really needs it to work, then you have to work with an attorney, an experienced attorney who knows what they're doing. Another thought that I had, if you want to give your assets to someone other than your kids, you really need to work with an attorney and ensure that that's written in the right way so that those assets are going to the charity that you want them to go to, or going to the person, the friend or sibling or whoever it is that you want those assets to go to, that it's going the right way. So now you probably know whether you want to work with an attorney or not, and what kind of attorney should you be looking for. And like I say, not all attorneys are the same. This quote that has come back to me time and time again from my parents: somebody has to graduate at the bottom of the class. Someone has to graduate at the bottom of the class. About this estate planning attorney who really underserved my grandmother when they were helping to write her estate plan. Again, I don't think this attorney was dull. I don't think this attorney really did a poor job in law school or really wasn't capable of learning estate planning. In fact, I bet they learned estate planning from a traditional estate planning person or from a traditional estate planning model. But this is what that looks like. This is what that typical experience looks like. In a typical experience, you're going to get form documents that are kind of set it and forget it. You're going to tuck them down into a drawer somewhere, and you probably won't really understand them. The attorney won't have taken the time to educate and really empower you about those documents, what those documents mean, and what kinds of things you should look for that might mean that there are changes that need to be made. That's the typical experience, is a kind of set it and forget it mentality about those form documents that have been cobbled together for you. Typical experience isn't going to keep money out of the Minnesota Department of Unclaimed Property or the Department of Unclaimed Property from wherever you're joining me from. This just isn't something that is considered in the realm of estate planning and estate planning attorneys. It's not something that they take care of. Typical experience might avoid probate, but it might not. And I told you the experience from my small estate planning law firm that I worked at, that we were not successful in helping our clients avoid probate most of the time. And unfortunately, that is the typical experience, is that there are changes down the road after the person is left, and those clients aren't revisited and their estate plans aren't revisited on a regular schedule. And so something gets missed, and there ends up needing to be a probate down the road when there shouldn't have been. Typical experience means that your family probably isn't going to stay out of court and out of conflict. Typical experience is only going to focus on the money. It's not going to focus on intangible things like your stories, things like your values, which are things that I capture in the estate planning that I do. The typical experience is going to leave assets to heirs unprotected without that asset protection that I talked about earlier, which is really that gift that you can give to your kids to make sure that their assets are protected from things like divorce and things like lawsuits. In a typical experience, you're not going to receive ongoing legal experience or ongoing legal guidance, at least not without huge hourly bills that you would receive from that attorney. And the typical experience isn't going to adequately protect your kids. It might have a long-term guardian designation, but nothing for the short term, and nothing that really gives you control and guides the future guardians that you would want for your kids. And really, you're going to be left with this question: will it work when you need it to work? But planning with me is completely different. It is truly a whole different experience. Planning with me is really planning for life. And I say that because I do things in such a different way. It's really a contrast to the typical experience. For one thing, I charge all flat fees, and you are going to get to choose the fee. And I say that, I'm not just throwing myself on your goodness and hoping that you will donate whatever you feel like is good to me. No, there are flat fee packages, and I'll walk through them with you, and I'll talk about what this is going to do for your family, what this won't do for your family. And you know your family. And so you know what they need, and you know what kinds of things they need. And you can choose the package that's going to do that. Or if you need to choose a less expensive package, and revisit it a later time, you can do that too. And I'll counsel you with that. And I'll accept whatever you choose, whatever package you choose. Planning with me keeps your money out of the hands of the estate. I believe that keeping money out of the departments of unclaimed property is an estate planning attorney's role. And I believe that estate planning attorneys can help with that by helping their clients to inventory the things that they have and maintain that inventory over time so that when something happens to them, the people that they love will know exactly where the assets are and how they need to be collected. Planning with me protects kids totally in the immediate and in the long term, including providing that valuable guidance to the people who are going to be raising your kids if you can't be there to raise them. Planning with me keeps your family out of court and out of conflict. Planning with me, you're going to be educated and you're going to be empowered. And you're going to know that you've made the right decisions because I will bring you along on the process, and I'll counsel you and I'll help you to make the decisions by educating you about what each decision means. Planning with me also means you're able to protect the family money from outsiders, from things like a divorce or a spouse who's looking to divorce somebody and wants to claim half of the inheritance that your child or the person that you love just received. You can protect that money and you can make sure that it's secure. And planning with me means a lifetime of guidance and protection because, again, I charge flat fees. I'm not going to charge you hourly rates when you pick up the phone and give me a call and say, great news, my first grandchild was just born, or great news, my first great grandchild was just born, or great news, we just moved into the house of our dreams. I want to hear all of that. And if there's something that we need to do to make sure that your estate plan is going to work under these changed circumstances, we can talk about that and we can make sure that it's going to work. If there are changes to your estate plan, there could be some fees involved at that point. And we would talk about that. We would talk about what's reasonable and what needs to be done in order to make those changes. But I'm never going to charge you for picking up the phone and saying, what is the name of my trust again? Can you remind me? Because I'm at the bank and I just opened a new bank account and I need to make sure that this gets into the trust. Never going to charge you for that phone call. Planning with me means that your plan is going to work when your family needs it to work. And it's really a gift that you're giving to the people that you love the most. And so you're probably wondering, after all of this, what should this cost, right? And I told you this is something that I was going to talk about because I know that this is something that's on the mind of everybody when estate planning comes up. And let me frame it this way. If all that you have is a house that's worth $400,000, planning with me is going to save your family $12,000. That's 3%, which, if you remember, is at the very bottom range of what probate is likely to cost. So if all you have is a house that's worth $400,000, getting an estate plan in place is going to save your family at least $12,000. And if you have assets over $3 million, then this planning is going to save your family at least 13 cents on the dollar for everything in excess of $3 million. The minimum that you would ever pay for planning with a typical death plan with a lawyer, and again, you can be almost guaranteed it's not going to work. It's not going to keep your family out of court and conflict. It's not going to ensure your assets aren't lost to the Department of Unclaimed Property. It's only going to cover your money. It's not going to cover your kids' immediate care or your values or your insights, stories, experience. All that stuff is not going to be covered. And it's going to cost at a minimum $1,500. If any attorney is charging less than $1,500, I don't know what they're doing, but they're not even providing that type of base level care. They're not even providing the base level of a typical death plan that you would get with an attorney. Or you can meet with me. I'm a personal family lawyer, and what that means is that I will work with you and I'll work with your family to really ensure that your family needs are going to be met. And you can choose your own fee, which is likely to range somewhere between $2,000 and $8,000. And you're going to know that your plan is going to work when your family needs it to work. And that's really the key, is having that certainty that your plan is going to work and that you're going to have a trusted advisor through your life to make sure that that plan is updated and that plan does exactly what you need it to do when your family needs it to do that. And I promised you that there was going to be some bonuses at the end of this presentation. And we have gotten to that point now. I'm going to go ahead and grab a link really quick. This link is to where you can actually schedule an appointment with me. And I want to give you a couple of things. The first thing I want to give you is a family wealth planning session, absolutely free. And what the family wealth planning session is, it's a 2-hour session where we'll sit down together and we'll talk about everything. We'll talk about the people that you love, and we'll talk about your family dynamics, and we'll talk about the people who might be the most helpful, the people who would be least helpful in helping with your estate or helping with incapacity and making decisions. We'll talk about your assets. We'll talk about exactly what probate would look like for you. Or we'll talk about whether you should be worried about the Department of Unclaimed Property getting some of your money. We'll talk about estate taxes and exactly what the estate tax picture would be for you, and whether it's a concern that you have or whether there's some planning that we can do in order to make sure that estate taxes aren't an issue for you. So we'll talk about all of those things and we can do it virtually as well. We can do it over Zoom, which is really how I've been doing most of these family wealth planning sessions. All you have to do is a little bit of pre-work, and I will give you that family wealth planning session with me for absolutely nothing. I want you to come to that meeting. I want to empower you and I want to educate you about exactly what is going to happen to your family and exactly what's going to happen to your assets so that you can make the best decision about exactly what you want to do about it. And you have all the control. You have, it's no obligation. So if you want to walk away, that's okay. I am just going to be happy to know that you have that information and that you know what's going to happen with your family. That's usually not the case. Most people continue on and they choose to do a plan with me, and they choose one of the plans that I have. And if you decide to do that, if you decide to choose one of the plans that I have to offer, I also want to take $250 off the plan of your choice. But in order to secure that gift, you need to book your appointment by the end of the week. And when I say the end of the week, I mean the end of the day, Saturday. And so why do I put this kind of arbitrary, you need to book quickly if you want that $250 off? I got to tell you, it's not arbitrary. The truth is, estate planning is a momentum thing. And right now you have the momentum. Right now you've come to a webinar and you've educated yourself about this topic. And my guess is that you're probably pretty fired up and you're probably ready to get an estate plan in place because you know that you want your family to be protected and you don't want them to have to go through probate and you don't want your assets lost to the Department of Unclaimed Property. And you want to put down your insights, your values, and your stories in some manner so that those can be shared with the people that you love. You want to have somebody who's going to be in place in case you become incapacitated, who can make healthcare decisions for you, who can make financial decisions for you. And you want to detail what those healthcare decisions are, and you want to detail what those financial decisions are. And I promise, I know this sounds like a lot, but I make this really easy for you. And my guess is that you're fired up right now and you want to do this and you want to get this done. And it's something that you've been putting off for a while, but now is the time. Now is when you want to get it done. And I limit this to the end of the week because it's a momentum game. And I want to encourage you to jump in and get that appointment scheduled. Get the next appointment on the books, because if you do, you can keep that momentum and you can get this done. If you don't, I will follow up with you. I will email you. I will reach out to you and try and help you get back to where you are getting your estate plan taken care of and you're getting it done. But the problem is it's hard to get that momentum started again. And a lot of times I see people kind of fall off and they aren't ready to book right away. They aren't ready to get that appointment on the books. And so they decide to wait. and they wait, and all of a sudden it falls off of their table again. It falls off of their to-do list again. And when that happens, a lot of times it doesn't get picked back up, and it doesn't get back on the to-do list, sometimes until it's too late. The best time to do an estate plan is just before you're gone, right? It's just like with life insurance. They say the best time to buy life insurance is just before you die. And maybe that's true with estate planning too. I don't even know if that is true, because I can tell you, having an estate plan in place lifts a burden off of your shoulders that you might not have even realized that you're carrying. But it is something that I know a lot of us carry. A lot of us worry about what's going to happen to my family after I'm gone, and how can I control it? How can I make sure that everybody is well cared for, and everybody is taken care of after I can't be there to take care of them? And so, again, I want to give you that $250 off the plan of your choice. But I want you to take this jump. I want you to get your appointment scheduled and get on my books, and make sure that you are continuing in your journey to get your estate plan done, and that you're not going to let it fall through the cracks. And so these are really your next steps. Schedule your free family wealth planning session. I told you I give you until the end of the week with the $250 towards the plan of your choice. And really, the reason that I give you until the end of the week, the reason that I don't require you to book right now, is because I understand. We've got significant others, we've got kids in sports, or we've got activities that we need to attend. It is, there's a little bit less of that right now, although things are picking back up again. But I want to give you some time. I understand that sometimes it takes some time to sit down with your schedule and make sure that you've got the right time that you're getting in. But I really want to encourage you to get it scheduled, to get on my book, and we can meet, and we can talk about these things, and we can talk about how much of a concern this is for you, and talk about exactly what would happen in your situation. If anybody has any questions that they want to ping off of me, now is a really good time to ask your questions, and I'm really happy to answer them. I'm really happy to answer any questions that start coming in here. One thing that I should note: if you've clicked into my book, or if you've clicked into my scheduling link, you've probably seen I don't have any more times available in June. And obviously, because it's June 30th, there are no times available in June. The availability in July is there might be one more meeting that's available in July. Really, I'm principally booking out into August. And the reason for that is I give my clients a lot of my time and a lot of my attention. And so I limit the number of client meetings that I can have on any given week and any given month to a kind of a select few. And so, again, you've probably seen that the availability for family wealth planning sessions is limited. And I hate that. I hate that I can't serve more people, but I know that to serve people at the level that I want to serve them at, I need to limit it, and I need to be able to really give them the time and attention that they deserve. So again, if you aren't seeing any availability in July, click over into August, and you should see some availability, and you should see that the availability does open up in September as well. But what does the family wealth planning session look like? I get this question a lot, and again, the family wealth planning session can be totally virtual. In the beginning, we're going to just talk with each other, and we're going to get acquainted. And I'll tell you about me, and I'll tell you about my law firm, and how, again, I'm different from a lot of other attorneys out there. But principally, we're going to talk about you, and we're going to talk about things like who would be the person to collect everything for you? Is there somebody in your life who maybe they're kind of a busybody, or maybe they're a really organized person that would do a really good job of collecting everything and would make sure that nothing got missed and that nothing got lost? We'll talk about what would happen if you became incapacitated. We'll talk about the court processes of guardianship and conservatorship, and how they can be expensive, and how they're really things that you can avoid by getting a healthcare directive in place and getting a power of attorney in place. Has anyone seen the movie I Care a Lot on Netflix? It's something that that might keep you up at night. I don't know if I'd watch it at night. It's kind of a horror type of movie where a professional fiduciary is taking advantage of elderly people and is having them deemed disabled or incapacitated and is taking over as their personal guardian. And I just want to note that that is something that you can shield yourself from by having a power of attorney in place and having a healthcare directive in place and really detailing there who you would want to serve as your conservator or as your guardian if you needed one. But that again, I wouldn't watch it at night, but it is something that is worth a watch, worth a look at. We'll also talk about what probate would look like for you, and we'll talk about the time, cost, and public nature of probate, and what that would mean for your family. And we'll talk about whether or not you're going to owe estate taxes. I'll even talk about, because there are some current proposals about the estate taxes and about step up in basis and that sort of thing. We can get into the weeds on that a little bit together, and we can talk about exactly what the future might hold and how you can really protect yourself and shield yourself against that into the future. And we'll talk about how do you want the people that you love to receive your assets. We'll talk about whether you want them to receive the assets outright. Typically people receive the assets outright either all at one time or in stages, something like a third at 25, a third at 30, and a third at 35. But we'll talk about whether that's right for you and whether that's right for your family, or if it makes more sense to keep things in a trust for them and to really protect them and provide some creditor protection from them, which again is something that they can't really build in themselves. It's something that that they can't do themselves for short of tens of thousands of dollars. Some other questions that I often get, SNTs, supplemental needs trust or special needs trust. Is that something that I'm capable of helping with? And the answer is yes, absolutely. It is something that I'm able to help with. And it's something that's really important. If somebody that you love is considered special needs, or if they're receiving some sort of government benefit that requires them not to have assets, not to have income, it is really important to protect that status for them and to make sure that they don't receive a huge inheritance where it's going to knock them off of the government benefit that they're receiving and is going to cause them to have to spend down whatever inheritance that is just so that they can reapply in the future for that government benefit and hopefully get reaccepted to it. I see here somebody saying, is there a typical age or stage of life typically will enact a living trust versus making short-term and long-term, making sure short-term and long-term guardians are in place and establishing a living trust later when hopefully assets are larger? And that's something that we can definitely talk about in the specifics of your situation. And we can look at, again, the principal reason that people do a living trust is because of probate and is because of the cost of probate and also the amount of time that probate takes. And so we can really look, we can really narrow down in your situation and say, is probate a concern for you? And is probate worth the extra cost of creating a living trust? Because there is an extra cost to planning with a living trust as opposed to planning with a will. And I don't push all of my clients to plan with a revocable trust or with a living trust. The fact is that it works for most people. Most people have enough assets, especially if they own a home, where planning with a living trust or planning with a revocable trust makes sense. It just makes monetary sense. It offsets enough. The cost of probate would offset so much that that it makes more sense to pay for the estate planning at this point and get it done. But I'm really happy to have that conversation with people. And again, it's not something that I push people into. Everybody gets to choose what package that they want. And if you want a will-based package, that's absolutely something that I'm going to honor. And I will help get those short-term and long-term guardian nominations in place very happily, because I know that that's really what's on the top of most parents' minds when they have minor kids and they haven't done estate planning yet. So that's a really good question. As far as, is it better to establish a living trust later in life? And I will say this: you don't have to rewrite a living trust every time you update your estate plan. You don't have to rewrite it completely. You don't have to start from scratch every single time. You can amend a living trust or a revocable trust. You can also restate a living trust, and most often that's what I help people with if they've already written a living trust, is where you restate the trust that they already had in place. And that means that if they've already funded something into the trust, that item is going to stay in the trust, and it will remain in the trust even when they restate it, that they don't have to go and put that asset back into the trust. But something that also might be real for a lot of people is, do I have to give up control with a living trust? If I'm going to put my bank account into the name of the living trust, am I going to have to give up some control over that bank account? And I just want to assure you that there is not a loss of control. There isn't a loss of control with a living trust. There are other trusts out there called irrevocable trusts as opposed to revocable. There are trusts called irrevocable that are set in stone. And that might mean that you have to give up some control. But the type of planning that I'm talking about right now, the type of planning that is right for most people, is planning with a revocable trust or a living trust. And there you don't have to give up any control. You don't give up any control over your home. You don't give up any control over your bank accounts. You don't give up any control over your brokerage accounts or anything else. You still maintain complete control, because again, you're not only the creator of that trust, but you're also the trustee, which is the person who has the control over the assets in the trust. And you're also the beneficiary, meaning you have all of the right to benefit from that trust at the same time. So you still have all of the control over those assets. I do get the question from time to time, what about nursing home costs? What about nursing home care? I'm really concerned about long-term care costs and the way that they seem to be spiraling up. And I don't know what to do. And I don't, and maybe my mom ended up having to go to a nursing home or a memory care unit because she had some early onset Alzheimer's or early onset dementia. What can I do to get in front of that? And what can I do to start planning for that? And oftentimes I get this from people who are in their 60s or 70s, and they have this concern about those types of long-term costs. And there I'll tell you, that's where things like the irrevocable trust start to come into play. That's where we start to look at some options to maybe give up some control over some of the assets, but to give up control in a way that you know what's going to happen, and to people that you really trust, to people that really have your best interests at heart and are going to make sure that you're well taken care of, and that they recognize that those assets are yours, that they're not their assets just because they're helping to steward those assets for you. But that they're really your assets, and they're intended to take good care of you. And so that's when we get into talking about Medicaid planning, when we talk about nursing home and long-term care costs, that's where we start to talk about a trust that would have less control. But that's not what I talk with most people. That's not the estate planning that I do with most people. It's possible that there are some people here with kids who are back for the summer from college. And it's possible that there are some people here who have kids that are going to be going off to college for the first time in September. And one thing that I want to say, I brought up earlier that there really is no age that it's too young to do estate planning. And I'm not talking about writing a living trust for an 18-year-old who, has nothing but their letter jacket and class ring to their name. I don't think that would be advisable to write a living trust in that kind of situation. But I am talking about certain planning documents that would be very good to get in place before that 18-year-old or 20-year-old or 19-year-old goes back to college in the fall. And that is a power of attorney and a healthcare directive, as well as something called a HIPAA waiver. And so parents, we give up, we lose a lot of our rights over our kids when they become adults. When they become adults, they can keep their healthcare information secret from us, and we can't go and demand it from the hospital. It's not the hospital's to be able to give, unless the kids have said that we can have access to it. And as far as healthcare decisions, making healthcare decisions for our kids, or helping them with their finances when they've gone away to college, if something happens and they become incapacitated, you're going to want to have a power of attorney for that child, and you're going to want to have a healthcare directive for that child, as well as a HIPAA waiver that allows you to see what's going on and see what's happening with their health, and to know if they're in trouble, that they are in trouble. And so I just wanted to mention that this is something that I include for those people who have somebody who's going to college. This is something that I think is really fundamental. It's a really important part of estate planning, is to make sure that those young adults are well protected, and that their parents are able to help them if that's what that young person chooses. And so if that's a concern of yours, or if you didn't know it was a concern until now, I want you to know that that's something that I am happy to help with. And it's something that I often help parents with newly adult children to take care of. One question that I often get is, who can oversee the money? Who oversees the money after I'm gone? And how do I choose that person? And that's really a question that I hope that you'll bring to our planning session together, because it really is dependent on the individual circumstances. There are some traits that I would say make a better personal representative or make a better trustee. And some of them you can probably guess: somebody who's organized, somebody who's good with money, but also somebody who shares your values and shares what you care about. And if it's really important to you that everything happen equally between your kids, sometimes you might want to avoid somebody who doesn't think the kids should receive equally. Somebody who thinks that they have done more of the work for mom and dad, for example, than they should have been called on to do. And so they're entitled to a little bit more than their siblings. You've got to watch for stuff like that when you choose the person who's overseeing the money. And that kind of guidance is something that I can really provide in the specific of your family situation, and something that I always counsel my clients through. Well, I have gone way past 8 o'clock. I hope people don't mind. I hope it looks like we've still got quite a few people on, and I love to see that. I'm really glad, again, to have you here with me. I'm going to go ahead and share my scheduling link one more time. And again, I want to encourage you to get on my schedule. I want to encourage you to meet with me and to be able to talk through the specifics of your situation with me, so that you know exactly what's going to happen in your family. And again, so that I can empower you to take control and not have the state's plan be the plan for your family, or not have a faulty estate plan that is going to subject you to things like probate and the cost of probate and the time that probate takes. I don't want that for you. I want you to have a plan in place that's going to protect your family, that's really going to protect and make sure that the people that you love are well cared for when you can't be there for them. So I just want to thank everybody for joining me tonight. I will be sending out an email with my scheduling link, and also with the recording of this webinar. It does take a little while for the webinar or the video to stop processing, and for me to get it uploaded. I will upload it to YouTube, where you can see it there. If anybody else has any questions, you can post them, and you might be able to get them in the next 10 seconds before I cut this off, or you can reach out to me directly, and you can either email me at timothy@tjslawoffice.com. You can call me at 952-215-5000. 4707, or you can bring those questions to either a phone consultation with me, which is available on my scheduling link, or to a family wealth planning session where we can really get into the nitty gritty of your family and the assets that you have and what's going to happen. Again, thanks everybody for joining me tonight. Thanks for taking this step on your journey to getting an estate plan in place for the people that you love. And I wish you all a very happy and restful night. Take care.